focused a lot on the more finite, important points of due process, which relate to the very essence of justice, knowing the case against you. And in the current secret court system that we have here in the UK, that's probably the most important part. When control orders went from control orders to TPIMs, everybody was focusing on the conditions that the men were living under. That these men, you know, their curfew is too long, they don't have enough movement, it's restrictive, it's abusive to the families, you know, and so we need to lessen those restrictions a little bit in order to make them more acceptable. Now, as part of the work that I've been doing for CagePrisoners over the last 10 years, I've travelled up and down the country meeting with people who have been placed on bail orders, on control orders, and now on TPIMs. And I can tell you the one thing that they complain about more than anything else is not the conditions, it's the aspect of secret evidence. Every single time they say exactly the same thing. Their children, who know nothing about the law, who know nothing about anything whatsoever, when you speak to them, they want to know, what is it that my father has done? Because nobody knows. And this is the main problem with this entire process. When it comes to deportation orders, he's not conducive to the public good. Why? Can't tell you. It's national security. Citizenship removal. Why is the citizenship being removed? He's an extremist. Why is he an extremist? Sorry, we can't tell you. In every single occasion, it's the same thing over and over again. We can't tell you, it's national security. But the terms are so vague that it's almost impossible to defend. Which brings me perfectly to our next speaker, David Gottlieb, who's going to speak about the sand in the machine, problems in defending innocent people accused of terrorist offences in the UK.
I think I better stand, because I'm not used to addressing people sitting down. May I start by saying what a tremendous honour it is for me to speak at such a distinguished panel. Of course, I know about Sir Geoffrey Byman from his reputation. And Sagir Hussain has been a very brave and solid companion with me on many cases. I know that both of them, during their long professional careers, have bravely stood up against injustice, often at great personal cost. And of course, I know Mr. Cadman, a fellow member of the bar, by his very high reputation. Given the eminence of this panel, it might be wondered what on earth I, as a mere foot soldier, somebody who's really ground his way defending knockabout criminal cases for the last 25 years, would have to contribute to such a meeting. But I'm going to suggest, I hope not too controversially, I hope nobody's going to disagree with this, that actually my experience is an important experience that needs to be communicated to the young. Because it is clear, I suggest, that in the last 25 years there has been a substantial sea change in the criminal law. Some of that has already been identified by the previous speakers. And a result of that sea change has been to collide with the introduction of new terrorist offences. And the consequence has been, whether it was intended or not, that innocent people now, more than ever in our nation's history, are at risk of being wrongly convicted. But I don't want to just simply give a speech of doom. What I want to show to you, based on my own experience, my own mistakes as an advocate, is actually there is still another way, that there's still much to be fought for. And there is no reason, if there are people who are strong in heart and mind, who will fight their client's corner and stand up against the state, why injustice cannot be prevented. Now, what are the rules of the game that have so drastically changed in the last 25 years? It's true that our Prime Minister, Mr. Tony Blair, said the rules of the game have changed. It's a very strange phrase for him to use, because actually up until that moment, no responsible person who worked in the criminal justice system had ever suggested it was merely a game. But that was his phrase, and that, I suggest, perfectly encapsulates the establishment conventional view about criminal trials. And it's simply this, that too many guilty people are getting off on technicalities. And how has this been addressed over the last 25 years? First, it's been addressed substantively by changing the criminal law. The effect of it, overwhelmingly, has been to whittle down the burden of proof and normally force a defendant who may be unpopular, who may have extreme views, who may not be guilty of the offence but may have told all kinds of lies because they're afraid they're going to be wrongly convicted of something they didn't do, into the witness box where their character can be assassinated. And so we've seen since 1990 failure to mention any fact that can be used by a jury to conclude a person is guilty. Anybody's previous bad character, even if it's not a conviction, even if it's just a tendency to tell a lie, can be used to show that this person is thoroughly dishonest and you don't have to rely a word of what he said. And as Sir Geoffrey said, it's been coupled with a sustained and, in his words, vicious attack on anybody who has the temerity to stand up against the state and say, hang on a second, before you railroad this person into prison, before you put them on a terrorism register and ruin their lives, can you just for 1 second just prove by evidence that this person is actually guilty? And I've got to say this, even though I know there are lots of law students in this room, it's also been coupled with a new form of legal education over the last 25 years. And that, in my opinion, I appreciate it's controversial, seems to be designed to produce one kind of lawyer only, and that is a corporate lawyer. Somebody who will respect the senior partner, someone who will not be a troublemaker, and someone, most of all, who has absolutely no feelings about their case. It's often said, in my profession, you must be dispassionate. You must give dispassionate advice to your clients. That's right. But this idea that a good lawyer doesn't care about his client, isn't fueled by anger at injustice and doesn't use that anger to fuel their work in their case, is, I suggest, the greatest, worst monstrosity of the last 20 years. It's this idea that lawyers are not supposed to care. We're simply robots in the machine. And I utterly, utterly repudiate it. I really hope that for the future there will be a new kind of lawyer, somebody who reads the law books but understands law is about justice, not some sort of technical rule to defeat justice, someone who cares about their client, and someone who truly sees themselves not as a corporate cog in the machine, but as a true champion of the people. Now, into this mix came 9/11 and the build-up to the war in Iraq. And as Asim has already said, we had Prime Minister Blair putting the establishment view, the rules of the game have changed. He probably put the argument more articulately than anybody else. And even on his retirement in 2007, he published an article in which he made it very clear it is a dangerous misjudgment, he said, to put civil liberties first. Now that is the establishment view. That's what we have to fight against. And it's a frustrating view because it's said by somebody who was a barrister, who one would assume would know a bit about the history of this country, who presumably was aware of Benjamin Franklin when he said, fighting the war on American independence. Somebody who puts security before liberty doesn't deserve either. But that's the establishment view. And how can it be challenged? And what I want to suggest is actually there's nothing new in this. Over the centuries in our nation's history, there have been times when particular groups have been vilified and attacked, where the laws have been changed and manipulated to get convictions. And it relies not just simply on acts of parliament providing human rights or laws, but on a core of people who have the courage to stand up and say this is wrong. And although I know it's very dangerous to use your own examples, cases as examples, I'm not doing it to show off. It is simply that I've noticed a tendency when you read a law report that it sort of tells you really a fraction of the picture of what happens. And it strikes me that some of the cases I've been involved in, which have been reported, actually had hidden agendas which would not be apparent. And I'm also hoping that maybe there'll be some people who will learn from the many mistakes that I've made and do a better job next time. Because one thing that I am absolutely confident about is in order to deal with the onslaught of terrorism offences that are coming through, there is a desperate need for new people with fresh ideas and fresh approaches, simply not to accept the same staid mantras that we mustn't challenge anything the prosecution says, you mustn't argue the law with the judge because that will annoy the judge. All those staid mantras have no place in the modern 21st war. That is a war in trial combat. And so one example I'm going to give is from my very first terrorism trial, when I had no experience at all, of a young teenager who had downloaded gone on the internet and looked at extremist material. Not material that you could actually build a bomb from, but just extremist material saying Al-Qaeda was a great idea. And he downloaded, actually, about Nelson's column worth of material onto disks. He hadn't actually read any of it, but he downloaded it and he was going to look at it elsewhere. And the prosecution in those days, because they thought they were being very, very clever, charged him with an offence called Section 57 of the Terrorism Act 2000. It was all brand new. And the idea was he was in possession of an article that could be used for instigating an act of terrorism. And because obviously the literature was terrorist literature, he must be guilty. And they started by saying this was a very dangerous man and he must be locked up in custody pending his trial. And I was lucky enough, I don't know why, but to be instructed by a very brave young man, Mr. Sagir Hussain, to represent Mr. Malik at the very first bail application. And I was told at the time by very senior people who had tremendous experience, almost as much experience as I now have myself. And they said to me, don't make a bail application, David. You're wasting your time. There are 3 other people in this case. They're all in custody as well. So the judge will refuse you. Just stay quiet. That'll help your career. And of course, being young and foolish, I went off to the Old Bailey in front of a judge that I was told nobody had ever successfully appealed in his life. And I went to him and I said, I want to make a bail application. And the judge rolled his eyes in disgust. He said to me, I can mention this all because I'm all retired now, thankfully. He said to me, I've got a very busy list, Mr. Gottlieb, really busy. I've got very important cases to do. I've got a murder trial, there's a jury waiting. I can't waste my time hearing this bail application that you know is bound to lose. So will you just go away, think about it, and can you just please withdraw this bail application? Well, again, being very young and foolish, I refused to do it. I said, this is a young man. He's a completely good character. There's no history of being an extremist. In fact, he downloaded the material 6 months before he was arrested. He'd been on bail all that time. What on earth was the public interest in being remanded in custody for potentially 1 to 1.5 years while his trial awaited? And the judge didn't even listen to what I said. He was tapping his fingers on his desk. When I finished speaking, he said, bail refused, and gave no reasons. Now again, I was told by very eminent people, almost as eminent perhaps as I am now, that I was wasting my time with appealing that case, because of course no judge at the Old Bailey would ever be successfully appealed in a higher court. But I took that case to appeal, and it's interesting to note because again the judge who heard that, Lord Justice Sedley, has now retired. He gave me a hell of a time when I was in the courtroom, and if you were to read the judgment, you'd make it sound as if, gosh, what was this incompetent lawyer doing arguing bail? The reality is that I can now reveal is just before, the day before I made that appeal, I had a phone call from somebody who claimed to be totally unconnected with Lord Justice Sedley. He was, how am I doing for time, all right?
Yeah, you're doing it.
He was his clerk, and he said to me, David, Mr. Gottlieb, the judge would just like you to know that there's a particular House of Lords case that he's aware of that he would like you to cite in argument tomorrow. And again, if you read the judgment in Malik and Central Criminal Court, it appears to be a judgment that's got nothing to do with the fact that when I went to argue bail, the judge refused to listen to me in complete violation of any natural rule of fairness or justice. The appeal decided entirely on the rather arcane basis of whether or not the bail application hearing should be in public or not. And I think it's a very important lesson for any young lawyer to learn, that the law report doesn't tell you the whole side of the story. Now again, the arguments I was raising were not new. They'd been argued before. In 1942, when Nazi Germany had conquered almost all of the Soviet Union, and German troops had seized Tobruk, and the very lifeblood of the British nation was almost being choked off by U-boats severing the trade in the Atlantic. There was a case in front of the House of Lords about a German immigrant, Mr. Liversidge, who'd been detained by the Secretary of State. And the Secretary of State said he had the power to detain because under wartime regulations, which were very broadly drafted, he could detain anybody he wanted. And when Mr. Liversidge's appeal was heard by the House of Lords, the majority of the House of Lords said that was right. It's wartime and the Secretary of State can do what he wants, however unreasonable that is. But one judge stood out against that. That was Lord Aitken. He said that in the clash of arms, the law is not silent. And he utterly rejected this idea that you could interpret a statute in a sort of Humpty Dumpty way, saying it means whatever you want it to say. Now, Lord Aitken, I understand, was shunned by the other members of the House of Lords for the rest of his life. They refused to dine with him. And yet the truth is, nobody now can remember who those other lords were. And we all know that his dissent is actually the law now following IRC and Westminster. And that argument that you shouldn't take an offence which is very broadly drafted and give the worst possible conclusion is an argument that I took sustenance from. And I was really very ably assisted, remember, at the time by my junior Faisal Safi. And we drafted an argument for the court in Malik to say this offence of saying somebody is in possession of terrorist material, therefore they must be guilty of a terrorist offence, is wrong because you've got to show some kind of link between the actual material the person is in possession of and the commission of an act of terrorism. Now, when I made that argument, you'll be interested to know, because it's not in the law reports, two of the senior advocates who co-defended with me stood up and said to the trial judge, we disassociate ourselves from that argument. We think it's wrong. So it's no surprise that the trial judge ruled against me. But we know from the final judgment of the Lord Chief Justice in Zafar that it was that argument which the Lord Chief Justice accepted in the Court of Appeal when they said, actually, if you're going to use this offence to prove somebody is a terrorist, you've got to show a real connection between the actual material the person is in possession of and an act of terrorism. And of course, it's as a result of that further laws were passed, including now the dissemination of terrorist publications in 2006. So the battle goes on. But those principles of looking back in the past to see how people in the past have dealt with similar draconian offences apply today. And finally, there was the case that I was very lucky and honoured to represent just last month at Woolwich Crown Court. And that was a young 19-year-old woman called Salma Kabal. The chairman was very kind enough to say that my client described me as inspirational at the end of the case, but the truth of the matter is this. She had suffered for a year and a half sustained, completely inaccurate press reporting saying that she had wanted to be the fourth lion, that she was going to go off and fight jihad with her estranged husband, that she herself supported terrorism, and so was guilty of failing to disclose that her husband was a terrorist. When we got to the trial, of course, and the prosecution's case had to be tested under cross-examination, and the permissible limits of what conclusions could be drawn from their evidence was actually exposed, it became apparent that that whole version, repeatedly in the press, was wholly false. And the trial actually ended with the spectacle of the prosecution and the trial judge saying to the jury, if they thought that Miss Cabal was actively dissuading her husband from going and becoming a terrorist, and that the only reason that she hadn't reported to the police was because she was 19 and she was ignorant of the fact that there was a law requiring her to report to the police, and the police already knew all the information that she was in possession of because they had secret recordings in his house, they could still find her guilty. Well, this is the last myth that I'm very anxious that everybody here knows is wrong. Even during that trial, I had the experience of senior members of the bar coming up to me in the rowing room during the trial and saying, David, we really appreciate everything you're doing, but you must realise it's a hopeless cause. The woman is going to be convicted. The mood is just terrible. No jury is going to want to acquit this person. And again, it's not something that's mentioned in the Daily Mail, but the jury that heard Salma Kabal's case certainly didn't look like a jury that would be sympathetic to a 19-year-old from Birmingham wearing a headscarf who was a beautician and who said in her evidence that her main interest was shopping, particularly shoes. 11 of them were white, 8 of them were men. But when they came back with their verdict, incidentally, a verdict that they came back with in less time it would have taken them to hear the recorded prose of evidence that the prosecution and the trial judge told them they had to hear before they reached a verdict. After they reached their verdict of not guilty, they all stayed in court. And it was extraordinarily humbling to watch them and see them, because every single one of them was in tears. They were in tears because they knew that not only had they done justice and reached a true verdict, but which is actually more important, they had done right by this woman. And I wanted to really end on her case to show you that this fight for justice is very hard. Those who go on that course will have a long and lonely existence. And at every stage, there are temptations to divert you. At every stage, people will say you can do an easier way, you can earn more money becoming a commercial lawyer. Your career as a judge, far, far quicker if you do something else. But I don't want anybody to be under any illusions that there is no greater honour than to represent somebody who is innocent of a charge, to stand up firmly for justice, whatever the consequences, whatever the risks to ourselves or our parents or our relatives. And as we are in the Lord Bingham group, I don't think I can really do any better than to end with Lord Bingham's famous words at the end of his book that I think suggests everybody reads on the rule of law. And it was simply this: what makes the difference between a good and bad government? I would answer, the rule of law. In a world divided by differences of nationality, race, colour, religion and wealth, it is one of the greatest unifying factors, perhaps the greatest, the nearest we are likely to approach to a universal secular religion. It remains an ideal, but an ideal worth striving for, in the interests of good government and peace, at home and in the world at large. Thank you.